when the latter die testate again with probate, then there comes in the chain of representation. A died with a will. In the will, appointed B as the executor. B applied for probate of the will of A. So this is the normal process under priority 1 of Rule 19 for a normal probate. This we'll discuss in a while. General feature, nothing unusual. In order to establish the chain of representation, then B, being the executor, armed with the probate of the will of A, then B went on to administer the estate of A, but not yet finished the estate administration. Then B died. When B died, B has the capacity as the last testator. Okay? So on the death of the last testator, in order to invoke on the chain of representation here, then B himself must make a will naming C as the executor of the will of B. Then what it takes is again the normal probate issuance in favor of C in respect of the last will of B. Again, this is a simple normal process. The only requirement that we need to satisfy is that B, having died the last surviving executor of A. So, in these two sequences of different years, we have a total of 2 simple probate being granted, both granted under Rule 19 of Captain A. Then, on the second probate being granted in favor of C as the sole executor of B, on that moment, C automatically acquires 2 capacities. Capacity 1, C is the executor of the will of B. Second capacity, C is the executor by representation of the will of A in respect of the unadministered estate of A. This we call the chain of representation. So the procedure is not complicated at all. It's the legal consequence that creates the convenience. For example, when A died leaving a Taikuzing flat, not just sold in the lifetime of B, then in our example just cited, C needs only to rely on number one, the original probate of B in favor of A, and the new grant of probate of C in respect of B's estate. You register these two probates on the Taikuzing property, then C will have all the authority required in order to sell the Taikuzing property of A by virtue of these two executors, by virtue of these two probate, by relying on the legal doctrine of chain of representation. This is usually much faster and more convenient. And this is one reason why one should die with a will, having named an executor, in order to provide for this possible long waiting time for administration of estate. All right. Now, this is part of the extract of a probate. Now, take a look at this. So, on a certain date, the last will of the deceased proved it and granted to the executor. The sole executor named it in the said will. Now, in Hong Kong these days, in terms of the grant application number, it will be the same number that you apply for the grant. So day one you make the application, it will be accorded with this HCAG number ABC of 2021. And when the grant is issued, it's the same number. It's the same number, no change. Then this is a letters of administration. Okay, now let's take a look at probate. Let's go back to the one that we have just seen. I'd like to draw your attention in order to show that this is a grant which is issued in respect of a deceased who died, as you can see in the sixth line down. Deceased died in 2021. You see that? 2021. And therefore, the grant number must be 2021 or later. Common sense. You only apply for a grant after the person died. Okay? Cannot be before. Then look at the top left-hand corner. The top left-hand corner is blank. No wordings. That shows that estate duty has been abolished. The law needs only asset disclosure. No more estate duty for deceased who died after 2006. And so in this is confirmed by the date of death, 2021. Okay? This one is not the same. This one is the second type of general grant, letters of administration, no will. You can see the grant application was made in 2019. The top is the top line, the first line from top in the middle there, 2019. That means the grant application was made in 2019, 2 years ago. And yet, if you look at about fifth line down, you see the time of the disease in fact, the date of the disease in fact took place in 1973. For your present purpose, that means this is a case of pre-2006. If this is the case, then you need to have estate duty clearance. All right? Now, this kind of understanding is required when in the examination you are asking about questions of necessary grant application documents. Since this is a case of a deceased who died before 2006, although the grant was made or applied for in 2019, you still have to comply with the necessary grant application documents on the basis that the deceased died before 2006. So this is the point that I want to pay attention to. Now, there are lots of issues or controversy in terms of the authority. Now, the authority goes like this. On the one hand, you talk about the authority of the personal representative. In that sense, you will see whether the deceased died with or without the will. Now, you don't care about whether he is an executor or not. Your concern is whether the deceased died testate or intestate. In both, he may be an administrator. One is administrator with will, the other is administrator without will. If we talk about the authority of the personal representative by way of an administrator without the will, then his authority comes only from the law. There is no limitation nor expansion in terms of rights, obligations, and authorities. Everything goes according to the law. Then you ask another question on the authority of the court. This will be more complicated because in terms of the authority of the court, it has nothing to do with testate or intestate. It has a concern by reference to domicile, as well as the location of property. It is generally understood that a court of Hong Kong shall have authority to supervise the administration of a estate only in respect of those property within the jurisdiction. that is to say, in Hong Kong. According to the private international law, there may be difference in terms of what the court can do arising from or in respect of overseas assets. So, if a deceased died domiciled in Hong Kong, with property living in Hong Kong and outside Hong Kong, then in terms of the supervision of administration of estate, then those properties situated in Hong Kong, the court will have jurisdiction. That being the case, that would make Cap 481 sensible. Otherwise, you cannot make an order under Cap 481 enforceable if a deceased died without property in Hong Kong. How can you enforce any order when there is no assets in Hong Kong to be enforced? The thing is, in terms of foreign assets coming into the hands of the Hong Kong personal representative, then it becomes a slightly more complicated issue, which is complicated by the basis upon which those foreign assets come into the hand of the Hong Kong personal representative. One of the deciding factors is whether or not the overseas assets come in a jurisdiction that requires no grant to be issued. In other words, there are foreign assets come directly to the hand of the Hong Kong personal representative as compared with foreign assets that come to the hands of foreign administrator, and then the foreign administrator send the residue of the asset in the hands of the foreign personal representative to the domicilian personal representative, assuming that the deceased died domiciled in Hong Kong. So these are the things that we will look at. Just to conclude our discussion on the above, therefore, we would consider, number one, is this Hong Kong a Hong Kong domicile? And then are the assets within in Hong Kong so that the court will have jurisdiction? And then to what extent are this liability to be accounted for depends on whether this is something already obtained by the foreign personal representative, the foreign administration, and then transfer the balance back to Hong Kong. So these are the serious questions that the Hong Kong court will look at in terms of administration of estate by a Hong Kong personal representative involving Hong Kong assets as well as foreign assets. Okay, so two factors I have given you to understand. Two factors. Number one, are the assets Hong Kong or are the assets outside Hong Kong? Number two, are the assets outside Hong Kong coming directly to the Hong Kong personal representative or via a foreign personal representative? So these will be the two factors that we need to consider. Before we apply for a grant, now you have considered this, your clients come to you, someone died, leaving assets, some in Hong Kong, some outside Hong Kong. One thing that we all need to do is to have different types of search. Earlier in this evening, we have already discussed about 3 types of search with the probate registry which you can conduct. Number 1 is the grant application search. Number 2 is the caveat search. Number 3 is a citation search. All 3 can be done at the probate registry. Get the name, get the ID card. You can then make a search. Very cheap, not expensive at all. But in terms of usefulness, in terms a lot of probate, Order 76 probate action dispute, the most useful type of search is the will search. Will search will cost about, I don't remember the current expense, current fees, probably $3,000. You pay $3,000 to the Law Society of Hong Kong in order to conduct a will search. Now, I think it is a widespread court-accepted practice in terms of will validity, in terms of interstate grant application, in order to prove that a deceased died without a will or without a valid will, then you make a search with the Law Society. Get a copy of the ID card, get a copy of the death certificate, then you make a search. Probably 99% no response. But having done a will search will give you the excuse to say that why is that your client is applying for LA? Well, yeah, we applied for LA because we have conducted a search and no response. So therefore, there is every reason for you to apply on the basis that the deceased died without a will. So, if subsequently a will is discovered, let's say LA already granted to your client, suddenly a will comes out and someone applying for revocation of the will, of the LA, what is your excuse? Oh, you know that there is a will. You turn a blind eye that there was no will. Blah blah blah. Or sometimes, well, you have on your initial interview, you have talked to your client. Your client say to you, well, there's no will, and also you make a will search and there is no reply. Then there is every excuse for you to believe the words of your client, which led to application and issue of LA. Even though subsequently, if there were any revocation, the chances are you will not be penalized by cost. Otherwise, you will be subject to heavy cost implication. So therefore, these days, very often the court, if there is a dispute about priority of grant, there is the court will usually ask the parties concerned to make a will search and confirm with the court that if there is or there is no response. So that is a modern practice that you have to be adhere to as a matter of course, particularly when the estate is not small. This is the estate collection procedure. Open the safe deposit box, HAD, funeral expenses, etc. Summary administration, personal application, application by solicitor firm. The last resort, if there are disputes, apply by way of solemn form probate business, meaning contentious probate business, under Order 76 to the High Court. So you can see these days the sequence of procedure in terms of the size and is it simple and straightforward that you can do it like you can pick any one of these. Okay? But if there is, it depends on whether there is any safe deposit box to be opened or not. Then you just follow these steps. But of course, sometimes people will ignore the HAD today because they would rather have things done all at one go. And after people are rich enough in Hong Kong, you have something to pay for by way of dinner expenses. It is item 6 that there is more and more contentious applications. As I've said, things may initiate as contentious application. Usually this is start by way of rounds and rounds of quarrel, hostility, and then different rounds of caveat to be issued, and then eventually end up with the Order 76 with the probate judge in the High Court. The court having decided one way or another whether this is the last will, whether the will is valid, whether he died intestate, whether you are the wife or you are the son of the intestate. Having decided all these issues, then the court application now turns from contentious back into non-contentious. The usual court order will say, all right, this is declared that the deceased died with or without a valid last will, or he died intestate, then LA is granted to, let's say, the wife. I declare that this is the surviving spouse of the deceased. This kind of declaration as to the relationship, and then eventually go back to the probate registry by way of non-contentious application. The same will also apply from what we were going to discuss about this application by different priority. Rounds and rounds of disputes, rounds and rounds of fight. Eventually the court will decide, okay, you guys, different camps, they fight against each other, drag on for a long time. The court eventually decided none of you shall be entitled to apply. So in all these big estate case, the cases, they will apply what we call the IPA, what we call the Independent Professional Administrator. This will come in two forms. Number one, general grant, IPA, Independent Professional Administrator. So, immediately granted. Or, alternatively, round one, a normal grant, LA or probate. And then the personal representative has done a lousy job, sitting there doing nothing, or having done an intermediate estate, giving no account, no estate account. Beneficiary got frustrated, got fed up. They applied to the court under Section 33, subsection 3, to remove the personal representative, and in their place, some IPA or some other family members are being appointed. So this is the way how things are to be done these days. This is the picture. How to have estate to be administered. No need for grant. No need for grant means summary administration. Summary administration. There's no grant issue, but some kind of certificate will be issued, enabling estate to be administered summarily. Not more than 50,000 HAD. Not more than 150,000 probate registry. You can see summary administration, one of the conditions always is there is no debt. There is no debt. So therefore, the normal concept of residual estate simply does not apply. They only talk about the estate. So here we are not talking about the residual estate not exceeding 50,000. It's rather the whole estate not exceeding 50,000. Same with probate registry, 150,000. The only difference between the, apart from the money, in terms of the nature of the assets, for HAD is cash or cash in bank. For probate registry summary administration, again is cash and cash in bank, including also the MPF. Only these three types of estate are capable of application by way of summary administration not exceeding 150,000 with the probate registry by the official administrator. Then when a grant is needed, now remember, when a grant is needed, it does not mean that the estate will exceed 50,000 or exceed 150,000. It simply means that it may include estate of any value. Any value. So for example, you have small estate 50,000, but there are debts. HAD, not possible. Probate registry, not possible. You need to apply for a grant, although the estate is small, because it's small but not simple. High Court, any contention usually started with caveat or the fight of multiple wills. Then you started with the probate action or the 76. So this is a dispute. We say this solemn form probate business. Non-contentious, we say common form probate business. It's just a legal jargon. Okay. So you can see in terms of these four types of postal application, layman can apply in person in all four types of application. All right? Even though it's more common through solicitor firm when it's application in court, and in particular if this is solemn form probate business. So therefore, in order to get your role properly performed, you have to make sure that your practice is sharp and is expedient. Don't sit there and doing nothing, because your client may be able to apply if he were to apply in person, getting a grant faster than what you will get. So rather you do it the other way around, when there is a grant issued to some other family members by giving false information, you can then apply to revoke the grant, to saying that some important information has been hidden behind and there is no full and frank disclosure, which happens very often. By home application to be made, meaning grant application to be made, these are three things that we need to bear in mind. The person with grant priority himself. Any person can apply in person as long as he has the priority. Priority meaning he has the highest priority in the circumstances. So for example, if this is a spouse and issue, interstate, spouse and issue are both next of kin with beneficial interest, they may apply, or either one can apply, except that the spouse has the first priority. So you have to clear off the first priority in order to escalate the second priority into the highest priority. The second thing for us to remember is this attorney grant. Now I'd like to draw your attention to this attorney matters on succession and estate administration. It's very complicated. To apply for a grant, you can invoke on a power of attorney using the specified form by the one with the highest priority, exercising a power of attorney for some third party to apply for a grant in Hong Kong. There is no law to say that applicant must be in Hong Kong or a Hong Kong resident. Anyone can apply. The thing to remember is, for grant application, you can only appoint an attorney if you are residing outside Hong Kong. So if you are not a resident outside Hong Kong, you cannot execute a power of attorney so that some third party can apply for an attorney grant on your behalf. This cannot be done. But the law also allows, you have someone living in Vancouver, for instance, a resident in BC, Canada. He or she can come back to Hong Kong and execute a PA in Hong Kong, appointing some residents here. Because he only executes a PA in Hong Kong, this does not remove from the fact that he is a resident outside Hong Kong. He just comes back here for business, for fun, for visit. The other problem is attorney grant requires surety guarantee, which is or may be a problem because surety guarantee is very difficult to overcome because it is expensive. So the practice is usually a point for you guys. You can suggest that your boss, solicitor in your firm, as the attorney under the PA, and then apply for a grant. So someone, the original applicant, a Vancouver resident, coming to Hong Kong, sign a PA to your boss, and the grant is applied by your boss through your firm. In that way, you can get 2 sets of legal fees to be earned. Of course, there is a downside because you will make sure that the will is simple or your client is simple. You know, all kinds of tricky stuff makes it, you would rather not get involved at all. This kind of monkey business, you have to be very careful. Money is not the first thing. You get it, you're sure you can get it done, then do it. Otherwise, once you assess it, too risky, don't do it. Application by solicitor in Hong Kong is a legitimate reason for dispensing with surety guarantee. So this is one consideration usually by lay clients. But as I said, whether you would like to recommend that source, it all depends on how you see your client or the complexity of the estate to be administered. The third option is for the official administrator in the name of OA. A while ago, we mentioned OA in terms of summary administration when the estate is less than 150,000. Here is a separate function of the official administrator. Here, the administrator can apply for any type of grant as long as he agrees. Of course, the OA is also very choosy. Number one, somebody will guarantee the pay, usually 4,000 per hour, present rate, and it's not too complex. Once there is litigation involved, OA will be reluctant. This is what we have mentioned before, how, on what circumstances you would apply to invite the official administrator to make the application. The grant will be issued in the name of the administrator, official administrator, for options, where the next of kin is not a Hong Kong resident, next of kin is Hong Kong resident and consent to OA to apply, grant not issued within 12 months of death, next of kin is an infant. As I said, the OA will consider this on case-by-case basis. I just raised this to you in order to try to overcome the hurdle that you guys as a probate practitioner. You need to know, you need to be able to handle all this grant search, probate search, that is the grant search, KVIS, citation, will search, inquiry with the official administrator. All these are matters that you guys should be able to do it without any problem. All you need is a professional expertise to know when to do what. If you do it systematically, this can be handled and should be handled by you guys with the least of supervision from your boss. Okay? That is something, these are the ready options in your manual. Application made by Hong Kong solicitor firm only. This is something that you also need to be aware. Up to now, this has been a Hong Kong solicitor monopoly, which is still good to some extent. Apart from application in person, because there are all kinds of competition, barristers, non-legal firms, overseas law firms, and all these kind of people, you know, somehow they're related on estate planning and also the present scenery. There are all kinds of business and firms on an international level or even across the border. They would like to get their hands on estate administration, including grant application. All kinds of incentives, they want to do it. But because Hong Kong, they only allow either application in person or through the solicitor firm, thereby we are able to exercise certain comfortable control. Otherwise, things will go out of control because you got a grant and you sell the assets and you sneak away. This will create all kinds of problems. So therefore, at least, let's say until now, the Hong Kong Court is ready to accept, to grant this monopoly. We don't have the monopoly on will making anymore, and we still have this monopoly in applying for a grant, with the only exception as application by applicant in person. In this past few years, things are already improving. About 10 years back, we have been taking this probate grant application and estate administration as something to mean only negligible legal business. Negligible. So you tell people that, oh, who are you? Oh, I'm a probate clerk, head of probate department. They'll look at you with a smile, you know, small potato. You know, in the heydays, you know, when conveyancing, you do one conveyancing, one assignment, you can get 30,000, and you already waived the mortgage. And lots of money. But then these days, when conveyancing business are down, IPO is not as profitable, and then when there are so many sizable estates, either contentious or non-contentious, decent probate practice will mean a lot of business. I remember having learned it from one friend. Well, because of the Lina Kong's case, that case has cost is the best fee earner for that city firm for that particular year. It never happened before. So expensive. They make a lot of money on the Lincoln case. Fight and fight and fight and fight. And after the Lincoln case, we have, several cases like this. I do expect that things will continue to be on the run, and you can imagine when all these contentious probate cases, look at their legal team. Usually fight by solicitor, solicitor instructing one counsel. And on these leading probate cases, you have a city firm instructing a team of counsel consists of 3 SC plus 1 junior. So 1 SC was 3 junior, of 2 junior being SC. So you can imagine 1 day court fee probably may mean more than 5 million. So it's a lot of money. A lot of money because we got lots of money. So I don't mind, giving some to the solicitors. That's why it has, resulted in this. But you guys, if you have a probate practice, you have a decent litigation background, that should be able to make your way up. Because what they need is somebody who is systematic, meticulous, and this will be you guys. Mode of application. This is unique in Hong Kong. You make application, you file the application in person, either by a firm or apply in person. You still have to make the personal filing to the court. The postal application not allowed it. The only difference is when there are requisitions, must be by fax. Probate registry will raise the requisition by fax, and for you to file the application in person, make the questionnaire, book an appointment to file the reply on requisition to the probate registry. So this is how things are done presently. The others are fairly simple on the grant application steps. One thing in terms of the practice, these days, the probate registry are ready to accept the payment of all court fees in one go. So usually we need to pay $72 and $265, both as filing fee and issuing fee. Because of all this takes time and because of this complaint about the delay, the probate registry, by way of practice, is now agreeable to accept fees all in one go. So once you start the application, you pay the 2 sets of court fee, that will be done. That will reduce some application time. Alright, so that's about it. I think we should leave it for next time, the rest. Okay. That's all for this evening.